All right, peace and blessings, everybody. It's Tuesday, March the 20th, the year 2018. I'm going to go out of order, believe it or not, and we're going to read pages 301 through the end of the book, page 351. I have a pressing need to understand the ending and a conclusion, and I'll come back and cover pages 251 through 300, or maybe 201 through 300. We'll cover it all. But I'm going to jump out of order, and when we put the whole book together, of course, we'll put everything in the right order. So this is a Cesspool of Judicial Corruption, written by David Hinkson's father, starting the top of page 301. And I wish you guys had a professional reader, but you're stuck with me. The district court concluded that Hinkson had not been sufficiently diligent in discovering the new evidence. It wrote, "The court finds that defendant is unable to establish that the failure to discover this evidence was not due to his counsel's lack of diligence. The court finds that defense counsel had ample time to investigate Swisher's prior record to trial, but was not diligent in pursuing the issue." In support of its conclusion that Hinkson had not been diligent, the district court pointed out that Swisher had testified to receiving battlefield injuries from his military service during an October the 11th, 2004 deposition in a civil suit involving Swisher and Hinkson. Hinkson was represented in that suit by Wesley Hoyt, one of the two attorneys representing him in his criminal case. In further support of its conclusion, the district court pointed out that Swisher had discussed his purported war injuries even before the deposition during his grand jury testimony on April the 16th, 2002, and February the 10th, 2004. Swisher's deposition in the civil case took place just 3 months before the start of Hinkson's criminal trial. That was the first time Hinkson was put on notice of Swisher's claimed battlefield injuries. Judge Fletcher touches on the errors made by Judge Talman. The following opinion is lengthy, analytical, and comprehensive. Chapter 44. The en banc decision is not final. Judge Fletcher's opinion is a perspective analysis of David's trial under the district court Talman. As the district court knew or should have known, precisely because it was grand jury testimony, that testimony was kept secret from Hinkson, the government finally turned Swisher's grand jury testimony over to Hinkson pursuant to the Jinx Act on January the 4th, 2005. And only 1 week before trial. Thus, the first time Hinkson was put on notice of Swisher's claimed battlefield injuries was on October the 11th, 2004. On January 14th, 2005, when Hinkson's counsel sought to reopen the cross-examination of Swisher in order to question him about the Tolbert letter, counsel stated to the court, "For quite some time, we have been trying to dig into his military history because we don't believe it's accurate." Then after Swisher pulled the replacement DD-214 out of his pocket, Hinkson's counsel stated at the sidebar that the defense had been trying to get Mr. Swisher's military records for about 90 days, and we have had very little control over when that happens. January 14th is 95 days after October the 11th. Thus, we know from the uncontradicted trial transcript that Hinkson's counsel tried to obtain Swisher's military record immediately after his October the 11th deposition. We also know that government authorities over whom defense counsel had very little control were slow to respond. The government did not provide anything to Hinkson until it provided the Tolbert letter on the very day of Swisher's testimony. The government can hardly claim that Hinkson was not diligent when his counsel sought the information immediately after Swisher's October the 11th deposition. It was the government that took 90 days to respond. In my view, Hinkson's counsel were diligent in looking for evidence that could be used to impeach Swisher. Indeed, they were successful in finding such evidence. As a result of their efforts, defense counsel received the Tolbert letter from the National Personal Records Center while Swisher was still on the stand. The letter recounted that Swisher did not enter active duty until 1954. It stated that Swisher's Marine Corps record has been carefully examined by Military Awards Branch, and that office has stated that his record fails to show that he was ever recommended for an award or awarded any personal decorations. Hinkson's counsel reasonably viewed the Tolbert letter as exactly the sort of impeaching evidence it had been seeking. Counsel hoped that Swisher, when confronted with the letter, would be forced to admit that he was not the decorated combat veteran he purported to be. Counsel could hardly have anticipated that Swisher, after being shown the letter, would pull from his pocket a forged document purporting to provide a superseding account of his military service. Until that moment, there was little reason for the defense to suspect that the existence of Swisher's replacement DD-214, let alone to suspect that the document was a forgery. After learning of the replacement DD-214 on Friday, January 14th, the defense was quick to investigate its authenticity. On Wednesday, January 19th, following a long holiday weekend, defense counsel informed the court that they had learned that Swisher had recorded 2 different DD-214 forms with Idaho County, and that the earlier recorded DD-214 was devoid of any honors and medals. Counsel has stated that they had spoken to staff at the National Personnel Record Center, who stated that the center stood by the conclusions of the Tolbert letter, but would not release additional documents about Swisher without a subpoena from a judge. The court agreed to subpoena Swisher's military file, which arrived 2 days later on Friday, January 22nd. The court kept Swisher's military file to review over the weekend and then disclosed it to counsel on Monday, January the 24th, the last full day of testimony before closing arguments. The court ruled that it would allow the defense to recall Swisher for further cross-examination, but would not allow the defense to introduce into evidence any of the military documents obtained. The court stated further that it did not want to conduct a mini-trial during which the government would put experts on the stand to explain the documents. Once Hinkson's trial concluded, the defense was diligent in obtaining the evidence from Woodring and Miller. It filed its motions for a new trial just over 1 month after the conclusion of trial. The government had its own duty to investigate Swisher's military record, having been alerted to the real possibility of a false testimony. Because the government had participated in grand jury proceedings, it knew long before Hinkson's counsel that Swisher had given potentially false testimony about his military experience. Swisher's first grand jury testimony was in April of 2002. This was 2 years and 3 months before Swisher's deposition, and 2 years and 6 months before Hinkson's trial. During this period, if it had wished to do so, the government could easily have obtained Swisher's official military file to determine whether its star witness was telling the truth. But so far as the record shows, the government made no effort to do so. The government now argues that Hinkson was not diligent in investigating Swisher's military record. But 2.5 years, it was the government that virtually made no effort to investigate the trustworthiness of its star witness. Further, it was the government that took 90 days to respond to Hinkson's request immediately after Swisher's October the 11th deposition for information about his military record. Yet the government now has the nerve to argue that it was Hinkson who was not diligent. It is almost incomprehensible to me that the government would make that argument. It is entirely incomprehensible that the majority would accept it. The third part of Harrington test requires that the newly discovered evidence be material to the issues at trial. In the context of a new trial motion under Harrington, materiality has a special meaning. Materiality under Harrington does not require that the evidence in question would have been material at the original trial. Rather, materiality under Harrington requires that the evidence in question will materially alter the result on retrial. In many cases, there will be little or no practical difference, but the Harrington test is clearly framed in terms of what will happen on retrial rather than what happened at the original trial. As I discussed below in addressing Harrington's fifth requirement, I conclude that the newly discovered evidence of Swisher's fabrications makes it probable that a new trial will result in acquittal. Thus, I also conclude that the new evidence is material under Harrington. The majority relies on evidentiary rulings made by the district court. It notes that the district court held that documents showing that Swisher lied about his military record were inadmissible under Federal Rule of Evidence 608B. The majority further notes that the district court excluded the evidence under Rule 403. As discussed above, the district court's evidentiary ruling under Rule 608B was wrong as a matter of law, and its ruling under 403 was an abuse of discretion. The majority does not merely hold erroneously that the evidence was correctly excluded by the district court. It goes further, suggesting that because the district court properly excluded the impeaching documents from evidence under Rule 608B and 403, these documents could have no material effect on retrial. Even if this were true, this is irrelevant under Harrington. The materiality test under Harrington is not whether the newly discovered evidence, the Miller and Woodring affidavits, would have been admissible during Hinkson's first trial. The test is whether the newly discovered evidence would probably result in acquittal on retrial. As I discussed in detail in Part 5 of the Harrington test, I conclude that the Miller and Woodring affidavits would probably result in acquittal on retrial. The affidavits would not have to be admitted into evidence to have this effect. If Swisher takes a stand and is asked about his military record, and if he is asked whether he lied under oath about the record at the first trial, the truth will necessarily come out. There are two alternatives. If Swisher tells the truth will come out through his testimony. If Swisher lies, the government will have professional obligation to correct the record and to disown the testimony of its star witness. The fourth part of the Harrington test requires that the new evidence be neither cumulative nor merely impeaching. The district court concluded that the substance of both proffered documents is not new and is generally cumulative of previously available information. The previously available information to which the court referred consists of the documents that came to light at three different points during the trial. First, the Tolbert letter, used by defense counsel to cross-examine Swisher on January 14th. Second, the Dowling letter, which the prosecution gave to the court on the morning of January 21st and which the court also received later that day as part of Swisher's official file. And third, the remainder of Swisher's official military file, which the court received on the afternoon of January 21st. During trial, the district court concluded that these documents established neither that Swisher's testimony was false, nor that the replacement DD-214 was fraudulent. On Monday, January 24th, after reviewing Swisher's military file, including the Dowling letter, over the weekend, the court told counsel outside the presence of the jury that it found the file very difficult to decipher and stated that the truth of the matter was not at all clear. The court told counsel that the documents in the file were neither self-authenticating nor self-explanatory and did not conclusively decide the issue. The Dowling letter, written by an officer in the headquarters of the U.S. Marine Corps, stated in plain language that Swisher had not earned any personal military commendations and that the replacement DD-214 was a forgery. Another fact finder may have found this evidence sufficient to show that Swisher was a forger and a liar, but the district court was explicit in saying that it found the evidence then before it was inconclusive. The district court stated that the only way to resolve the uncertainty surrounding the silent file would be to hear from a records custodian from the National Personnel Records Center or someone who is familiar with military records and decorations than any of us. The prosecutor agreed with the court's assessment and added, what the defense would really have to prove if this were to be resolved, is that the substituted DD-214 signed by Captain Woodring in, I believe, October 1957, that the signature of Captain Woodring was forged, and I would suggest that probably would resolve it's correct or not. How you would prove that something that was signed in 1957, how you would prove that something was signed in 1957, I doubt very much Mr. Woodring is still with us, but I don't know. Precisely the additional evidence the court said was lacking was supplied by Hinkson in his motion for a new trial in the form of an affidavit from Chief Warrant Officer Miller. Miller is the U.S. Marine Corps liaison officer to the National Personnel Records Center. His job is to evaluate the authenticity of information, records, and documents affecting individual Defense Department transfer documents, including DD Forms 214. Miller concluded after a thorough investigation that the replacement DD-214 was a forgery and that Swisher had not earned a Purple Heart or any other personal commendation. Similarly, precisely the additional evidence the prosecutor said was lacking was supplied in the form of an affidavit from the now retired Colonel Woodring. As it turned out, Colonel Woodring is, to use the prosecutor's words, still with us. Colonel Woodring stated unequivocally in his affidavit that his signatures on both the purported 1957 letter to Swisher and the replacement DD-214 were forgeries. In sum, the court stated at trial that the evidence before it was insufficient to allow it to determine the truth or falsity of Swisher's evidence. Defense counsel then presented to the court, in support of the motion for a new trial, precisely the additional evidence the court and the prosecutor said was needed to resolve the uncertainty. In this circumstance, this new evidence cannot possibly be considered cumulative. Impeaching evidence may properly support a motion for a new trial under Rule 33. Indeed, we have expressly rejected the proposition that impeachment evidence is never sufficient to warrant a new trial. If the witness testimony were uncorroborated and provided the only evidence of an essential element of the government's case, the impeachment evidence would be material under the Hinkson test if it were discovered after trial that the government's star witness was utterly unworthy of being believed because he had lied consistently in a string of previous cases. In denying Hinkson's motion for a new trial, the district court wrote that the proffered evidence, i.e. Miller and Woodring affidavits, is impeachment evidence and so is not a valid basis for a new trial. It is apparent from this statement that the district court believed mistakenly that as a matter of law, impeachment evidence may never provide the basis for a new trial. As just discussed, our cases do not so hold. The majority concludes that the Miller-Woodring affidavits are impeaching and therefore cannot satisfy the fourth requirement of Hinkson. It writes, evidentiary admission of the extrinsic Miller and Woodring affidavits would serve no purpose other than to impeach Swisher's testimony as to his military record rather than his testimony as to Hinkson's solicitations. The majority mistakes the nature of the Miller and Woodring affidavits. They are powerful enough to permit a jury to conclude that Swisher's testimony inculpating Hinkson, the only uncorroborated testimony implicating Hinkson, was on the 3 counts for which the jury convicted him, was totally incredible. The fifth Hinkson requirement is that the new evidence must indicate that a new trial probably would result in acquittal. I conclude this new evidence would probably result in acquittal at retrial. I so conclude after comparing the evidence presented at trial on the 3 solicitation counts on which Hinkson was acquitted and the 3 counts on which he was convicted. A judge ruling on a new trial motion may choose not to describe that evidence in detail, but he or she must necessarily consider it. Given the nature and importance of this case, I describe it in detail so that the reader may understand the basis for my conclusion. The 3 solicitations to murder were charged in counts 1 through 3 of the indictment. In these counts, the government charged that Hinkson had solicited James Harding in or about January 2003 to murder Cook, Hines, and Lodge. The jury acquitted Hinkson on all 3 of these counts. 3 more solicitations were charged in counts 4 through 6. In these counts, the government charged that Hinkson had solicited James Harding on or about March 17, 2003 to murder Cook, Hines, and Lodge. The jury deadlocked on these 3 counts. 3 more solicitations were charged in counts 7 through 9. In these counts, the government charged that Hinkson had solicited Swisher between about December 2002 and February 2003 to murder Cook, count 7, Hines, count 8, and Lodge, count 9. The jury returned a verdict of guilty on these counts. Finally, 2 threats to commit murder were charged in counts 10 and 11. In these counts, the government charged that Hinkson made statements to Annie Bates in which he threatened to murder the children of Cook, Hines, and Lodge. The evidence was persuasive that he had done so. Again, we have only the testimony of the gang who had a vendetta against David or wanted to steal his company. To do that, the best way was to have him locked up for life. The issue was whether Hinkson had been serious in his request. That is, the issue was whether he had an actual intent that Cook, Hines, and Lodge be killed, which was required under 18 U.S.C. 373A. The persuasive evidence was from those testifiers who lied to the jury, but whose testimony was rejected. Only if Hinkson was serious in soliciting the murder of Cook, Hines, and Lodge, that is, only if he had an actual intent that they be killed, did he commit a criminal offense. The jury acquitted Hinkson outright on 3 of the 9 counts charging solicitation in violation of 373A. On these 3 counts, the jury concluded that government had not shown that Hinkson had been serious in soliciting murder on that occasion. The jury could not make up its mind on 3 more of the counts, were unable to conclude unanimously that Hinkson had been serious in soliciting murder on that occasion. The jury was able to conclude unanimously only on 3 counts, counts 7 through 9. The counts involving Swisher that Hinkson had been serious in soliciting murder. To assess the likelihood of an acquittal on retrial on the 3 Swisher-related accounts, I compare the evidence on the 3 Harding-related counts, counts 1 through 3, on which Hinkson was granted an outright acquittal. Judge Fletcher quoted much of the testimony of Swisher, Harding, and Bates, but he concluded that on the 5th Harrington test, the jury would acquit David. He said, on retrial, impeachment of Swisher would not be so limited. The parties now know conclusively, based on the Miller and Woodring affidavits, that Swisher forged his replacement DD-214 and his purported supporting letter from Colonel Woodring, and that he used these forged documents in an effort to obtain veterans' benefits. The parties also now know conclusively that Swisher never served in combat or earned any personal military commendations, and that he was not injured in battle overseas but in a private automobile accident near Port Townsend, Washington. And they now know conclusively that Swisher lied under oath during the first trial about participating in secret combat missions in North Korea, about being wounded in action, and about receiving a Purple Heart. At a new trial, the government could put Swisher on the stand to testify, as he did at the original trial, that he told Hinkson that he was a decorated Korean veteran who had killed too many people. The government could then argue that Hinkson, believing these things, seriously solicited Swisher to kill 3 government officials. But this time, on retrial, the defense counsel and government would know the truth. Defense counsel would impeach Swisher by asking if it were true that he was not, in fact, a Korean War veteran, that he had, in fact, not won a Purple Heart or other awards, and that he had not, in fact, been injured in combat in Korea, but rather in a private automobile accident. And, in fact, he had lied to the Idaho Division of Veteran Services about his injuries and non-existent medals in an attempt to get military benefits to which he was not entitled. That would already be bad enough, but it would get worse. Defense counsel would ask Swisher whether the last time he appeared in court to testify under oath against Hinkson, he wore a Purple Heart lapel to which he was not entitled, presented a forged replacement DD-214, and lied about his military record. This time, defense counsel would not be left defenseless if Swisher were to choose to lie in response to these questions, because this time the government would also know the truth. If Swisher were to lie in response to any of the questions, the government would be obligated to correct the record. See NAPU 360 U.S. at 269, Hayes v. Brown, 399 F.3D, 972, 978, 9th Circuit, 2005. In short, a new trial would be a disaster for the government. A new jury would not only learn, as the first jury did, that Swisher and Hinkson, once friends, had become bitter enemies by the time Swisher testified. It would also learn, as the first jury did not, that Swisher had no compunction about lying under oath to serve his ends, and that he had lied under oath and produced a forged documents at Hinkson's first trial. Therefore, conclude under the 5th part of the Harrington test that a new trial would probably result in acquittal. Summary. Because Hinkson's motion met all 5 requirements of the Harrington test, I would hold that he is entitled to a new trial on the Swisher-related counts of soliciting murder. Conclusion. The district court committed 2 errors, either of which was sufficient to reverse its decision and grant Hinkson a new trial. I would reverse the district court's denial of Hinkson's motion for a new trial because 1. The district court erroneously precluded Hinkson from introducing documents into evidence to show that Swisher lied about his military record and forged his replacement DD-214. I would also reverse the district court's denial of the motion for a new trial because 2. The newly discovered evidence produced in support of the motion satisfies the 5-part Harrington test. But what happens when cronyism and politics prevail? Chapter 45, Legal Reporter Levine on en banc decision. Recorder staff writer Dan Levine wrote the following article after the decision of the 11-judge en banc hearing. Conservatives on the Ninth Circuit U.S. Court of Appeals rode to the rescue of one of their own on Thursday, finding that Judge Richard Talman didn't botch a bizarre murder-for-hire case in Idaho. The en banc decision from Judge Carlos Bay reverses an earlier opinion that blasted Talman for refusing to grant defendant David Hinkson a new trial. The author of that panel opinion, Judge William Fletcher, now writes in dissent, Bay and Fletcher largely talk past each other. Bay, a former state trial court judge, used the case to give district court judges more cover on abuse of discretion calls. Fletcher, a former UC Berkeley School of Law professor, essentially accused Bay of cherry-picking the facts, saying his version of events was too truncated. A Justice Department spokesman declined to comment on the ruling. Not so, said Hinkson's defense attorney, Dennis Reardon of Reardon and Horgan in San Francisco. Any legal rationale that prevents a jury from learning that the only witness the government has on the charge came before the jury with the express purpose of lying to them and showing them forged documents can't possibly be an appropriate or correct standard of a fair trial. Federal prosecutors charge Hinkson with attempting to hire his one-time friend, Elvin Joe Swisher, to kill an IRS agent, a prosecutor, and an Idaho district judge. A taxed protester who made his living running Water Oz, a company that sold water with small bits of dissolved gold and platinum over the internet. Hinkson hated federal authorities. He spoke of building a fedapult, which was a device to catapult federal... Hinkson hated Hinkson hated federal authorities. He spoke of he spoke of oh, bear with me here. I'm going to make my way through this. I'm sorry. Breathe. Tell myself to breathe. He spoke of building... Okay. Just pause here for a second, okay? Just hold on. He spoke of building a fedapult, which was a device to catapult federal agents into a canyon or into an oncoming train, according to the opinion. At trial, Swisher appeared on the stand bedecked with a Purple Heart, which he claimed was a product of a service in the Korean War. When the defense tried to challenge the medal, Swisher produced a military document which purported to prove its authenticity. Faced with conflicting evidence in Swisher's personnel file, Talman let the testimony in, and Hinkson was convicted. After trial, when the defense supplied an affidavit from an officer calling Swisher's document a forgery and proving that he never served in Korea or won a medal, Talman didn't order a new trial. Instead, he sentenced Hinkson to 33 years, which he is serving in a supermax prison for terrorist suspects. Talman sentenced David to 30 years plus upward departure of 3 years on Swisher's testimony and another 10 years for phony structuring charges. In his opinion, joined by 6 others, Bay tightened the abuse of discretion standard. We invoke the standard of review as we have hundreds of times before, but this case forces us to step back and consider precisely what abuse on discretion means. Bay wrote, "From now on, a district judge's factual findings can only be reversed if they are found to be illogical, implausible, or not supported by inferences drawn from the facts." He wrote, "This decision gives trial judges unbelievable power, but is constitutionally unlawful. If any of these three apply, only then are we able to have a definite and firm conviction that the district court reached a conclusion that was a mistake," Bay wrote. Talman's decisions passed this test, he concluded. Joining Bay were Chief Judge Alex Kozinski and Judges Mareed Scanlane, Andrew Kleinfeld, Consuelo Callahan, Sandra Ikuta, and N. Randy Smith. Fletcher didn't take on Bay's new standard, but instead ticked through a list of mistakes he says Talman made. For example, Talman said Hinkson's lawyers waited too long to investigate Swisher's war records, when in fact Fletcher wrote that they had been waiting for a response from the military for months. It is almost incomprehensible to me that the government would make that argument. It is entirely incomprehensible that the majority would accept it, Fletcher wrote. He was joined by Kim McLean Wardlaw, Richard Paez, and Harry Pregerson. Reardon plans to ask the Ninth Circuit to hear the case, and failing that, the U.S. Supreme Court. Maybe we shouldn't be surprised that a former trial judge would want to change the law in order to give trial judges decisive power. As Talman said at David's trial, "You can always appeal my decision. Yes, if you can afford it. However, with this interpretation of the law, there is no effective way to appeal even the most corrupt judges. Not everyone went along with the Bay majority opinion and decision. Let's consider what our fighting men had to say." Chapter 46. 17,000 Korean War vets speak out. While all this was going on, Swisher was paddling upstream. From prison, he was begging for mercy because of his discomfort, while spending only a couple of weeks in jail for just a few of his crimes. One must give him credit for his persuasiveness, golden tongue. He has been able to con his way out of trouble almost without exception. Even with all his phony lawsuits, his rapes, his perjury, his stolen valor, he hopes society will honor him as a great American. But he is nothing but a craven coward. His audacity, impudence, and disrespect for humanity make him very dangerous to moral people. In my opinion, he is totally amoral. John Romer of the Daily Journal staff writer wrote about an amicus brief filed with the Ninth Circuit Court of Appeals by attorney John W. Kecker on behalf of president of the 17,000-member Korean War Veterans Association, William Max Swain, San Francisco. Prominent attorney John W. Kecker of San Francisco's Kecker and Van Nest is a Marine veteran with a combat record that Elvin Joe Swisher could only dream of. Swisher, the star government witness at a federal murder-for-hire trial, lied on the witness stand and claimed bogus military credentials, offended and resentful at what veterans groups call stolen valor claims, such as Swisher's. Kecker filed a passionate friend of the court brief in favor of defendant David Roland Hinkson. Kecker argued it was fundamentally unfair that jurors convicted Hinkson without ever learning Swisher's deceptions. Swisher's testimony was key as he told the jurors how defendant Hinkson asked him to torture and kill an IRS agent, and Assistant U.S. Attorney and U.S. District Judge Edward J. Lodge of Idaho in retaliation for a tax prosecution. But Swisher lied a lot. He produced a forged document that falsely said he won a Silver Star, the Navy and Marine Corps Medal, the Purple Heart, and a Navy and Marine Corps Commendation Medal with Combat 5. He testified wearing a sham Purple Heart replica pinned to his lapel as he wrongly declared himself a Korean War combat veteran. Kecker was a real Purple Heart earned as an infantry platoon leader wounded during Operation Hastings, a major 1966 encounter with the North Vietnamese Army in Qua Tri Province. Hinkson cited with admiration Swisher's claims of combat service and offering him $10,000 per victim. Swisher testified in a plot that derailed when Swisher went to authorities, but jurors never learned they were listening to a fraud. All right, I'm going to stop at the top of page 321, and I'll come back a little bit later. All right, picking up with page 321. Following a 3-week trial, Hinkson was sentenced to 43 years in prison for attempting to hire Swisher to kill the officials. Now a fierce battle rages at the 9th U.S. Circuit Court of Appeals over a controversial decision to deny Hinkson relief based on evidence of Swisher's fakery. Much of the definitive evidence that Swisher lied arrived from the National Personnel Records Center only near the end of the trial, and the trial judge, Circuit Judge Richard C. Talman of Seattle, sitting by assignment, excluded it and later ruled against a new trial. Talman held that it was Hinkson's belief in Swisher's tall tales that counted, not whether they were actually true. Hinkson's appellate lawyer, Dennis P. Reardon, of San Francisco's Reardon and Horgan, is an old friend of Kecker's who asked him to look at the case. Kecker read the record with mounting disbelief at the idea that a judge would trivialize as collateral impeachment a guy who gets up and falsely says, "I'm a war hero." Kecker proudly displays on an office wall an AK-47 assault rifle sculpted of animal bone. A North Vietnamese soldier may have used an actual weapon of that type during a firefight to shatter Kecker's left elbow and riddle his left leg with bullets. He retired from the Marine Corps as first lieutenant in 1967 to attend Yale Law School. He founded Kecker and Van Nest in 1978. His damaged left arm and other wounds are an ever-present reminder of his combat service, and he remains angry at blowhards with war stories. "You hear about it all the time," he said in an interview on Tuesday. "Football coaches, tough guys in town, and hall meetings. When I hear some guy brag about his military service, I'm always suspicious." Since around 1980, Kecker said the country has turned pretty solidly pro-soldier. Even as we debate wars, people who served are recognized and applauded. And so many charlatans try to glom onto that. Kecker, in his Hinkson brief, represents William F. McSwain, a Texan and former Army Master Sergeant who is president of the 17,000-member Korean War Veterans Association. The veterans are as upset as Kecker at the spectacle of a fake war hero on the witness stand, but Kecker's brief is also an unusual plea on his own behalf. Mr. McSwain is represented here by John W. Kecker, who served as an infantry platoon leader in Vietnam, while a first lieutenant in the United States Marine Corps until he was wounded and retired from the Marine Corps in 1967. Kecker wrote, "Mr. Kecker received the Purple Heart. Mr. Kecker has an impressive background as a member of President Reagan's National Security Council in the 1990s. Law professionals recognize him as one of the very top attorneys in the U.S. He entered into this fray pro bono because he was so incensed by what Swisher had done to undermine the credibility of true warriors and had gotten away with. In the Hinkson case, Kecker wants a new jury to hear about Swisher's record of dishonesty before they decide to trust his accusations against the defendant. The appeal seeks an en banc rehearing or a full court en banc review. But Kecker said he is disturbed by the fact that Ninth Circuit judges are in fact judging one of their own colleagues, Talman, who heard the case in Boise, Idaho in 2005. In a 7-4 en banc decision in November, the circuit affirmed Talman's decision, making at trial U.S. v. Hinkson, 585 F.3D 1247, November the 5th, 2009, the majority redefined upward the degree of deference an appellate panel owes a trial judge, holding that only illogical or implausible trial court rulings amount to an abuse of discretion warranting reversal. Talman's rulings did not meet the new standard the majority held. Does Kecker think Talman's involvement swayed his fellow circuit judges? Judges always tell you they are immune from any human frailties when they put on their robes, and we have to believe them. If we get up and say we don't believe them, we get thrown in jail, Kecker said. Kecker took particular offense at Talman ruling that evidence proving Swisher lied about his service record was not material to the issues at trial and was merely impeaching because it did nothing more than attack Swisher's credibility regarding his military service rather than his testimony regarding the solicitations to murder. Murder charge, according to language Kecker cited from the appellate record. As he put it in his brief, what amicus is asking this court to understand is that its reasoning and language are a slap in the face to veterans and jurors alike. Kecker wrote to the circuit, "For they imply at a time when this nation is fighting 2 wars and losing more soldiers every month than the average American, no longer attaches any significance to a veteran's wartime service. If the jury had known about Swisher's lies," contended Hinkson's lead appellate lawyer Reardon, echoing the en banc dissenters, "at least some of the jurors might well have considered fabricating military commendations to be an act of deceit powerful enough to render everything that person says totally incredible. Government lawyers opposed Kecker's entry into the case as a friend of the court. First, let me assure you that we take very seriously the significance and honor of military service. U.S. Department of Justice appellate lawyer Michael Taxay wrote to the Kecker firm. However, Taxay went on, the primary legal question before the Ninth Circuit concerned the deference that ought to be given to certain district court rulings. Relevant here was the government's theory at trial that defendant Hinkson had solicited Swisher to commit murder because of Hinkson's subjective belief that Swisher had killed in combat. Swisher's actual military experience was irrelevant to the government's case. A Department of Justice spokesman declined to comment further, said Kecker. This shows that the government is perfectly happy to have fake combat veterans testify before criminal juries, but objects to letting real combat veterans like Mr. McSwain be heard in the Court of Appeals. Civil service employees, career politicians, and lifetime tenure judges must justify their behavior in the eyes of the public. To be exposed for incompetence or fraud can have serious consequences. Don't search for the truth. Understand your role. Get a conviction and sustain it. So appoint damage control specialist to spin the facts. Chapter 47. Better to destroy one man than to retry subsequent cases. Fay and I had been under the opinion that eventually, if all else failed, 24 judges called a super en banc could be impaneled to hear the entire case. In other words, it would be like a district court trial, but instead of a Judge Talman listening to all the witnesses and running the show, the entire panel of judges would hear the case. Was it naive of me to believe that this could occur? There was a certain amount of comfort knowing or believing that if truth were presented to a larger body of judges, common sense and honor would prevail. Needless to say, but the District Federal Department of Justice was upset with the conclusions drawn by the minority judges as expressed by Judge Fletcher in the dissent opinion. Acting United States Attorney District of Idaho Michael J. Mullaney of the Counterterrorism Section National Security Division, Department of Justice, wrote on May the 7th, 2010, the following in his brief to the Ninth Circuit Court of Appeals. Judge Talman's decision was predicated upon detailed findings of fact. An appellate court is not at liberty to substitute its judgment of facts for that of the trial judge. Instead, factual determinations are reversible only if they are illogical, implausible, or without support in inferences that may be drawn from the record. The holding that Hinkson challenges does not satisfy the criteria for an en banc review and warrant the unprecedented step of granting further review by the entire court. There is consequently no reason for this case to become the first in this court's history to receive plenary. This would be the first super en banc in the Ninth Circuit. Hinkson was convicted of soliciting Elvin Swisher to murder Judge Edward J. Lodge, AUSA Nancy Cook, and IRS agent Stephen Hines, who had all been involved in his tax investigation and prosecution. At trial, Swisher, James Harding, and Rich Bellin all testified concerning Hinkson's solicitation to murder the officials. According to Harding, Hinkson offered him $10,000 apiece to torture and kill the three officials. Bellin, who had worked for Hinkson, testified that after Hinkson's arrest, his animus toward the officials became the focus of his life. Hinkson told Bellin that he would pay to see them dead. No corroboration, just the word of the Honorable Richard Bellin. Relying upon the multi-factor test in United States v. Harrington, Talman explained that the defense had not been diligent in seeking the evidence it now possessed. The court, by having acknowledged before trial that it was suspicious of Swisher's claims concerning his military record, that Woodring's statement, and that his signature had been forged, was cumulative of previously available information concerning Swisher's military record, and that the newly discovered evidence was not material because whether Swisher was actually a combat veteran and seasoned killer was not relevant to whether Hinkson believed that he was. After all, if Swisher said it, it must be true. With their crystal ball, the prosecutors were able to get into David's head. They knew what he was thinking, or were they just taking Swisher's word without any corroboration? Dissenting Judge McEwen observed that in granting a new trial, the majority has assumed the role of a super trial court rather than a reviewing court. This is an interesting play on words. What is a super trial court? What is the purpose of a reviewing court? And in so doing has failed to give deference to taking Talman's word unchallenged to any of the district courts, Talman's detailed filings. The inquiry is not whether the trial court made findings the appellate court might not have made, but whether the trial court's resolution of the motion resulted from a factual finding that was illogical, implausible, or without support in inferences that may be drawn from the facts in the record. In this context, the words illogical, implausible, or unfactual are totally meaningless. Here, Mullaney quotes Judge McEwen, who sat on the bench in the first appeal in Seattle, and uses her argument as something persuasive. She had ruled that the Harrington test totally discredited David's appeal for a new trial. Talman's detailed findings were composed of Swisher's lies and the testimony of Harding Bates, for which the jury acquitted David or could not reach a verdict. Mullaney argues, we cannot conclude that the district court's decision was so unreasonable, illogical, or arbitrary as to constitute an abuse of discretion. Where there are two plausible views of the evidence, we should not reverse a factual finding unless we believe the finding is so illogical or implausible that a clear mistake has resulted. Clear error reviews permits only limited re-examination of factual findings where the district court's account of the evidence is plausible in light of the record viewed in its entirety. Mullaney argued, here Judge Talman not only identified the correct legal standard, he also made extensive and careful factual findings in applying that standard to the circumstances of the case. Judge Talman afforded Hinkson an unfettered opportunity to cross-examine Swisher concerning his military record by reference to the impeaching documents. Hinkson, however, declined to avail himself of that opportunity. David, he claims, just didn't play the game correctly. Thus, you go directly to jail. Finally, since issuance of the Hinkson decision, a significant number of cases within the circuit have relied on it resolving abuse of discretion claim. Judge Talman's evidentiary rulings were correct. Here, Mullaney buried in his brief the main reason for the government's opposition to David getting a new and fair trial. A significant number of cases within the circuit have relied upon it. Granting yet further review could call into question the validity of those questions and generate uncertainty as to the correct standard for deciding similar claims. Now the Ninth Circuit may have to reconsider other cases if a single judge's opinion becomes gospel. All of the false testimony of the blackmailer, thieves, conspirators was accepted as a truth and acted upon by one man, Judge Richard C. Talman, a judge who was caught meeting with Swisher during the trial in his chambers. Again, I draw attention to the fact that Swisher was in a wheelchair supporting a catheter and barely recuperating from his heart surgery, and that he was not even welcome to call David. In addition, I had warned David that Swisher is a liar and a crook, but Mullaney goes on. What did matter to the government's theory of the case was that Swisher told Hinkson that he had killed people in combat and Hinkson believed him, which explains why he chose to solicit Swisher as a contract murderer. In sum, Hinkson's attempt to involve the entire court in what Judge McEwen aptly described as a classic sideshow should be rejected. For the foregoing reasons, the petition for limiting rehearing on banc or rehearing by the full en banc court should be denied. Respectfully submitted, Mullaney. The appeal for a super en banc went to the Ninth Circuit for consideration. There was no further involvement of the defense except for the amicus brief from McSwain, Kecker, and Reardon et al. The same group of judges reviewed the same arguments and clung to their prior opinions. The decision filed July 14, 2010 was rendered except for with one change. They concluded, appellant's petition for rehearing by the limited en banc court and for rehearing by the full court is denied. However, to his credit, Chief Judge Kozinski joined with the four dissenting judges, Pregerson, Wardlaw, W. Fletcher, and Paez. The original en banc opinion filed on November 5, 2009 remains unchanged, except that Chief Judge Kozinski concurs only in the portion of the opinion that clarifies this court's abuse of discretion standard of review, but dissents from the application of the standard to the facts of the case. Chief Judge Kozinski in his dissent said, I continue to agree with and join that portion of the opinion explaining how we review for abuse of discretion, but now disagree with the application of the standard to the case before us. I had underestimated the trust some jurors would have placed in Swisher if they thought he was a decorated combat veteran, and the likely backlash if they had learned he was a fraud. My change of heart came about after I read the Supreme Court summary reversal in Porter v. McCollum, 130 S. Court 447, 2009, and the amicus brief of William McSwain filed in our case. Without Swisher, the government had no case. I'm now persuaded that Judge Fletcher has the better of the argument for the reasons articulated in his dissent, which I join in full. Now that the en banc hearing failed to free David, where do we go from here? The United States Supreme Court will have to decide if we must give deference to all trial judges in lieu of granting the convicted the opportunity to be heard in full. This is a significant case because it takes rights away from all U.S. citizens. In summary, let's take a flyby peek at what happened to David Hinkson. Chapter 48, A Panorama View. Granted, this is a complex case. We understand how it began, but we don't know how it will end. Former Idaho County Prosecutor Dennis Albers was almost right when he swore to David, "I'll put you in jail and get your business." He didn't get David's business. And hopefully he'll wear the medallion of dishonor for the rest of his life for his unrelenting attack on David. He and Annette Hasselone share in the guilt. The lawsuit against David and Annette, brought with Albers' involvement July 1999, mounted to outright theft. Any violations of rules or regulations for which David was ultimately responsible pale in the light of the crimes these two committed. The record shows that Hasselone and her cadre of co-conspirators made false reports against David. I don't know if David's attorney, Britt Groom, was part of the scam, but he called me sometime more than twice a day, pleading for me to send him $95,000 to put in his trust account for David's defense against Hasselone. He had assured me, "You'll get your money back as soon as the trial is concluded." I wired the money permanently, lost it. It all went to Annette and Dennis. Then in 2000, when the tax investigation began against him, David endeavored to engage the IRS in a civil law contest. David had faxed a notice to IRS agent Vernon saying that he intended to file a civil suit against him. The suit would establish his Seventh Amendment right to impanel a common law jury to decide whether he was required to file tax returns, even though he didn't owe any individual federal income tax. When in March 2000 he demanded a jury trial in an IRS civil damage case, the IRS advised him in writing that the investigation was civil. David ticked off IRS boss agent Vernon by suing agents Cook and Hines and him for $50 million. Thus it became personal when David sued him. In retaliation, Agent Vernon vindictively referred the matter for criminal handling. Then came the raid, November the 21st, 2002, which was spawned by false allegations to the FDA from Annette Hasselone and those at Eneva Corporation who conspired with her to steal David's trade secreted formulas. Assistant U.S. Attorney Nancy Cook offered to dismiss the criminal indictment against David if he would pay $5,000 and dismiss the civil suit against her and Steve Hines. David went to sheriff's office to file charges for theft against Mariana Raff, but instead FBI agent Long arrested David and threw him into solitary confinement, where he remained for years. Agent Vernon fabricated a phony accusation that David threatened to harm Steve Bernard, an ex-employee at David's company, Waterhouse, but Steve testified at trial that IRS agent Vernon was lying. David concluded that he was not required to file a tax return for 1994. He sought to have a jury resolve the question, but rather than deal with the issue, the government spread rumors to destroy David's reputation and pollute any jury pool. They winnowed the useful parties from all of David's acquaintances to make statements leading to David's conviction for not only tax issues but murder for hire. They worked the field assembling disgruntled employees who were willing to profitably participate in testifying to anything that David had machine guns, crates of ammo, and was the leader of the Mountain Man militia. The government agents held David in solitary while they spent the following year and 3 months trying to build a case. Mariana Raff kicked off the first attempt to bury David, but she was using feds as much as were trying to use her. Because of her string of unceasing felonies, they needed a substitute. Bring on Swisher. The IRS and Department of Justice work with the judge in the case, all of whom receive a cash bonus from the U.S. government under Title V for participating in the conviction of any person accused of a crime. Then during the trial, which is a mockery of justice and simply a dramatization, the judge admits only the evidence offered by the government and excludes any evidence offered by the defendant so as not to confuse the jury. They decided to use their tried and tested method of convicting an innocent person of crimes that never occurred. The tactic is to accuse the innocent person of murder for hire because no corpus delicti is required. Lies or hearsay of one individual is all they need. As John Pugsley states, history proves that government inevitably grow corrupt, and that corruption leads to an increasing use of police and military force, both against foreign enemies and against its own citizens. Agents of the government reluctantly admitted that David was convicted of a murder for hire based on the testimony of a person fraudulently claiming he was a combat hero. Joe Swisher paraded before the jury in David's trial with a Purple Heart medallion on the lapel of his black leather jacket, which stood out like a neon sign. The prosecutors lauded witness Swisher as a combat hero. They gave Swisher unimpeachable credibility in the eyes of the jury. Then, when it came time to show that Swisher was a liar, Judge Talman refused to allow any contrary evidence, even though the proof lay before the judge's eyes in Swisher's official military file. The government manipulated the media by publishing all the hate propaganda before the feds. By publishing all the hate propaganda provided by the feds, the media was willing to be manipulated by publishing all the hate propaganda provided by the feds. The media never conducted any independent investigation, which is supposed to be the fourth estate that keeps government honest. In fact, there was never any real investigation ever conducted, even by the government, only a search for those willing to accept bribes for participation in their conspiracy, which is straight from the KGB playbook. While David remained many months in solitary confinement, Judge Talman denied some of David's exculpatory witnesses the opportunity to testify before the jury, even though they traveled great distances to attend the trial. When Swisher testified that David plotted to kill these agents, the fact that David wasn't in the United States made no difference. The judge would not allow jurors to see his passport, even though David was in the Ukraine at the time. Swisher had the blessing of the court. He was allowed unchecked and with impunity to spew forth a litany of false and fraudulent statements. When a court will not enforce evidentiary rules to prevent a liar from making wild claims, the liar can be very convincing to a jury, especially a liar who has the skill and finesse of Swisher. Rather than looking into Swisher's military record to be certain that it was correct and not a forgery, and in spite of strong indications that Swisher was lying, the prosecutors, whose only motivation was obtaining a conviction of this innocent man, ignored their duty to investigate and do justice. One would think that if they were sincere in trying to learn the truth, they would have checked into Swisher's military claims and reputation for honesty. As Judge Fletcher pointed out, they had 2 years to check out his past history, and they failed to do so. Swisher fooled his comrades in the Marine Corps League that he was a legitimate war hero. He took great pains to write up his booklet, A Marine Remembers, and his numerous forgeries. He unabashedly decorated himself with honors due only to genuine war heroes. The stories he told made the listeners believe that they owe him an immense debt of gratitude for his personal sacrifice. In 1985, David was broke, but by November of 1993, he had researched how to manufacture ozone generators and then created a company called Water Oz. He took to the airwaves and became a popular guest on the Lou Epton Show. Former FBI agent Ted Gunderson, who had his own radio show, listened to David's shows and then invited David via telephone to broadcast with him over the shortwave radio from Nashville. While together on the air, David or Ted had said that Art Bell, a popular night radio talk show host, had been involved with an underage person. David admitted he had been misinformed and he publicly apologized. However, Art Bell filed a suit against Gunderson, David, and the station. In Gunderson's presidential campaign, he had borrowed Bobby Eve's money and couldn't repay it. He saw a chance to make good his debt with David's new company. Thus was born a conspiracy to infiltrate and take over Water Oz. The conspirators hatch an elaborate scheme to commandeer David's assets. Because of Albert's know-how and mission to destroy David, all parties were set to gain something. By July of 1996, Water Oz moved from Las Vegas, Nevada to Grangeville, Idaho. Jerry Gray approached David to work for him, then moved from Las Vegas to Grangeville. Jerry came with baggage. Her twin sister, Bobby Eve, Bobby's son and daughter-in-law, Annette Hasselone, the same person who sued David with the help of attorney Albers, were granted by the police in Las Vegas and Southern California. Jerry Gray pressed David to attend the Granada Forum in Las Vegas. He was treated like royalty. Then the conspirators descended on David at Waterhouse. Anthony Hilder, a close personal friend of Gunderson, said he wanted to make a video about David's case. He demanded David pay him $10,000 cash to make a documentary film called Prosecutorial Misconduct. David told him that he didn't have $10,000 to his name. David thinks Hilder and his cohort, J.C. Harding, came to ensnare him in the murder-for-hire plot. Arlene Olson called Wes Hoyt, revealing Gunderson's plot. She testified that Ted Gunderson, Nancy Cook, and J.C. Harding, by their acts and actions, did in fact form a criminal enterprise in order to fulfill their objective to vindictively prosecute David Hinkson for crimes that he did not commit. She mentioned two reasons for their motivation. One, to have David Hinkson drop his civil suit against Cook. Two, there was a possibility of great financial enrichment. The star witness that the feds planned to use was Mariana Raff. Her spurious statements to FBI agent Long in April of 2003 convinced the court that David should be detained in jail until his trial because he was too great a public safety risk. And Agent Long waited 17 months to check out the Raff story, but found that there was no truth in what she claimed. Using Raff as a witness would have spelled disaster for the government's case, so they came up with a different accuser, Elvin Joe Swisher. He now became the new star witness. Deputy U.S. Marshal David Meyer took the witness stand and testified under oath that it was too risky to hold the trial in Moscow, where David's peers would try him. At the trial, Meyer admitted upon cross-examination that he had no personal knowledge that David was a threat to anyone. I asked the Attic County jailers, did you deny David the use of his own computer? They told me they had the capacity to make a reasonable accommodation for David, and he could do his legal research. That decision, they said, was made by Deputy Marshal David Meyer. Pat Shannon, writer for the American Free Press, asked in his article, how can the federal jury be independent and impartial when the law permits the federal government to secretly award to judges secret cash awards? This is legalized bribery. Phyllis Schlafly refutes these two colossal myths propagated by the legal community for the last 50 years. One, the Constitution is whatever the Supreme Court says it is, and two, court rulings are the law of the land. Judge Talman openly lied about the evidence in front of him, which is judicial misconduct, but there is no forum except for impeachment to correct this great injustice. Slothful investigations by the Department of Justice result in unreliable findings. Far too much reliance is placed on information supplied by informants. Congressman Baumann said that most Americans know little or nothing about the widespread domestic use of police informants. Congressman Hyde affirmed the government's use of an army of well-paid secret informers, whom he described as a motley crew of drug pushers, ex-cons, convicts, prisoners, and other social misfits. Richard Bellin, before he testified against David, tried to take over Waterhouse with the help of Swisher and others. He sued me and others for millions, but was defeated. Judge Bradbury responded to Bellin's attorney, I cannot believe that there was a mutual assent based on the evidence before me that Mr. Bellin, with no consideration, would obtain 50% of a company that generates $15,000 to $35,000 a week. I just don't believe it. Bellin then sued Judge Bradbury, me, and Wes Hoyt for $5 million in damages and $17 million in punitive damages. We watch the same pattern of abuse, fraud, and deception by the Department of Justice and our courts in the cases of Congressman George Hinkson and Congressman James Traficant. Hinkson was in line to be the chairman of the powerful House Banking Committee. Congressman Kindness stated, I believe that George Hinkson's recent trial and conviction on charges of bank fraud was the direct result of a campaign by various members of the bureaucracy to stop the Congressional Accountability Project. Congressman James Traficant's case was also based on coerced and perjured testimony and fabricated evidence, just like in David's case. Amnesty International concludes that in our supermax prisons like ADX, conditions exist that constitute psychological pain and agony tantamount to torture. What we are doing is barbaric and inhuman. A person needs human contact. How can I come to any conclusion other than the obvious? The government of the United States is sick and corrupt. Is sick, broken, and corrupt. Chapter 49, Rowland's Opinion. I am categorically accusing agents within the United States government of criminal conspiracy. This conspiracy has been ongoing for many years in the name of justice, which is a pretext because it involves the denial of justice to the American people by depriving U.S. citizens their civil rights. I'm going to stop at the top of page 341. And we'll pick up a little bit later. All right, starting with page 341. Unbelievable, radical, You be the judge because the conspiracy is provable. Most people would rather hug the illusion that the American system of justice is fair and honorable. Yes, it was when it started out over 200 years ago, but what if there were proof that rogue elements within the system have now taken over and are operating outside the law? What if our Constitution is being or has already been overthrown and we are slowly becoming a police state? What if these rogue elements are conspiring to overthrow freedom in America? These are serious charges, and one must not take them lightly. Certainly, the culprits will make every attempt to destroy my credibility. I am the father of an innocent man who was falsely accused and wrongfully convicted of crimes that he did not commit, and in fact, crimes that never occurred. My son, David Roland Hinkson, is sitting in prison as I write this book, a victim wrongfully imprisoned. David is a charismatic person who became one of the many targeted individuals in the U.S. who, because of his political speech, has been singled out to be eliminated by the conspirators. The conspirators fear that individuals such as David, who are willing to speak out against corruption, will foment an opposition against them, their dirty deeds that will foil their plans to turn America into a socialist nation. As David's father, I am aware that some will automatically consider me both biased and non-objective. Regardless, I can't close my eyes to the truth I have seen, but nothing will silence me. Therefore, I have presented the cold, hard facts and will let you judge whether the system is broken. The story of treachery, deception, crime by officials shows how our son manipulated. The story of treachery, deception, and crime by officials shows how our government manipulated the conviction of my son, David Roland Hinkson. I welcome any credible evidence that disproves the allegations I make here. I have researched diligently and believe the statements made here are accurate, but I have tried not to overstate the enormity of my discovery of this conspiracy. I ask the reader to consider this. Is there a crime more cowardly than one orchestrated or conspired by agents of an all-powerful government against helpless victims? Not only did David's government set him up for a ruin, but it denied him a fair trial. With arms and legs chained, stuffed in a dungeon, he had to try to overcome the assumption of guilt. The named people identified in this book entered into a conspiracy and did falsely accuse him while he stood before the so-called bar of justice. He had believed that the rule of law prevailed in America. He believed that there was truly a presumption of innocence that worked for him, and he would prevail if he could show that those who made salacious allegations against him were liars and should be prosecuted or impeached. Now he has learned that the presumption of governmental regularity and correctness has replaced the presumption of innocence. He now understands that he is the victim of corrupt, broken legal system which now operates in the country of his birth. He is learning firsthand a hard lesson as to how the system really works, but has paid an extremely high price to gain that knowledge. If only he had the benefit of 20/20 hindsight while we were facing the future, we could have made many adjustments in the way his case was presented, which could have at least showcased the corruption and would have proven there was no truth in the allegations against him. We learned that during the middle of his trial, Judge Talman willfully lied from the bench about the content of the official file that the government gave him. Then, based on that lie, the judge made a finding of fact which was false and issued a ruling denying the admission of a critical piece of evidence that would have set David free. His excuse for what was that it would confuse the jury. The record is clear that the judge lied, but there seems to be no forum to overcome his deception. So David is destined to spend 43 years in prison at Supermax, USP, Florence, Colorado. David, founder and sole owner of Wateroz, employed over 40 people between the years 2000 and 2003. He had every right to sue the government agents of the IRS and Justice Department for racketeering because they were conspiring to bring false criminal charges against him through a baseless grand jury indictment. His reward was to begin his journey through hell. Assistant U.S. Attorney Nancy Cook actually encouraged a witness to lie to the grand jury, which is the crime of subordination of perjury. But the government has never charged her with a crime. Not only was it disruptive to David's life, his work, and his employees to be constantly scrutinized, but it was disconcerting that a federal prosecutor was actively advocating for and encouraging witnesses to tell lies against him under oath. The grand jury disbanded without bringing a true bill against David, but the U.S. attorney used fraud and a rubber stamp with the grand jury foreman's signature to create a fraudulent superseding indictment. Hold on. To give the appearance of legitimate charges against him. With this fraudulent document began an odyssey of epic proportions. Central to the issue of vindictive prosecution is the government's continued pursuit of claims that agents in the government knew or had reason to know they were not true. If they had reason to know the stories were not true, they had a duty to investigate and determine the truth. It's prosecutorial misconduct for a prosecutor to use perjured testimony. A prosecutor who does so acts arbitrarily and capriciously and violates the due process rights of the accused. The court also must be condemned for its failure to exercise its supervisory powers to demand that the prosecutor correct the record. A prosecutor who discovers perjury by a grand jury witness after the indictment is required to inform the defendant, the trial court, and the grand jury of the perjury, so that the grand jury may reconsider its decision to indict the accused. Justice and law require that they tell the jurors when they know a witness is lying. The widespread pattern of such misconduct in a case, especially the consideration of perjured testimony, requires the trial to use its supervisory authority to declare a mistrial whenever discovered. However, in David's case, the judge refused. Prosecutors, of course, want to get a conviction. Few even care if the accused is innocent, even though prosecutors have a dual role and swore to uphold the constitutional rights of the individual while prosecuting and to do justice. But prosecutors have developed the attitude that if defendants are wrongfully convicted, it's not my problem. They can always appeal. By law, prosecutors may not speak to jurors outside the presence of the grand jury, nor can they withhold exculpatory evidence which would show that the accused is not guilty. Cases of abuse have come before the courts where prosecutors presented perjured testimony and questioned a witness outside the presence of the grand jury and then failed to inform the grand jury that the testimony was exculpatory. Other cases include failing to inform the grand jury of its authority to subpoena witnesses, operating under a conflict of interest, misstating the law, and misstating the facts on cross-examination of a witness. But remember, under Title V of the United States Code, judges, prosecutors, and even investigators are all allowed to receive payments for convictions they participate in obtaining, which is legalized bribery. Let me remind you of what Justice Sutherland of the Court of Appeals of the Third Circuit said. The prosecutor's duty is to protect the fundamental fairness of judicial proceedings. That assumes special importance when he, the prosecutor, is presenting evidence to a grand jury, and that the cost of continued unchecked prosecutorial misconduct before the grand jury are particularly substantial because there the prosecutor operates without the check of a judge or a trained legal adversary and is virtually immune from public scrutiny. The prosecutor's abuse of his special relationship to the grand jury poses an enormous risk to defendants as well. For while in theory a trial provides the defendant with a full opportunity to contest and disprove the charges against him, in practice the handing up of an indictment will often have a devastating personal and professional impact that a later dismissal or acquittal can never undo. While the potential for abuse is so great and the consequences of a mistaken indictment so serious, the ethical responsibilities of the prosecutor and the obligation of the judiciary to protect against even the appearance of unfairness are correspondingly heightened. David's case is a good example of such abuse. It has cost David and his family in excess of $4 million so far paid for his defense. It was likely that the trend of his growing company, which was only grossing $3 million a year, could now be astronomical. Worst of all, an inventor who truly is a creative man, innocent of the charges against him, has spent 7 years in the most severe conditions of incarceration in the United States and is facing a virtual life sentence. David was detained by federal agents under a fraudulently obtained detention order based on the perjured testimony of an FBI agent who repeated as hearsay what Mariana Raff supposedly told him was true because she said her 2 brothers in Mexico had done this before. The use of such perjured testimony from a former disgruntled employees who had a vendetta against David when the FBI agent did not bother to conduct an independent investigation to verify what had been said was obstruction of justice, a separate crime committed by the FBI agent. Not only did they imprison David falsely for 17 months on this testimony alone, but the entire United States of America was at risk from a potential terrorist attack by these 2 men until the FBI finally checked them out. During the 17-month period, there were 2 unsolved murders of assistant U.S. attorneys, one in Baltimore, Maryland, and one in Seattle, Washington. If these 2 brothers of Raff had done this before, Agent Long, who was on the Northwest Task Force for Anti-Terrorism, had an absolutely duty to his country to investigate these two as persons of interest. The fact that FBI agent Long did not do so for 17 months and then only after repeated demands by David's attorney is proof that Agent Long knew all along that these two individuals did not pose a threat to the U.S., nor would they have been people that David contacted as potential hitmen. That this means that the government story of why they held David in detention from April the 9th, 2003 was bogus and fraudulent. They never should have held David in jail before his trial. Yet one of the government's objectives in destroying a targeted individual was to isolate the individual and prevent that person from participating in his own defense. Thus, the FBI had to invent an excuse to make it appear that David was the equivalent of a terrorist who was likely to order the murder of other federal officials if they didn't lock him up. The government has consistently interfered with David's housing while in jail by directing the Ada County Jail to periodically move him to solitary confinement and to reassign him to higher levels of security and to restrict his living privileges. The obvious intent of his captors was to increase his level of stress, cause greater isolation, and induce a psychological breakdown. These people threatened David's physical safety when they put him in a cell with a dangerous individual who strangled another inmate to unconsciousness in David's presence after the strangler had demanded money from David. David, who is gentle and nonviolent, was incredibly stressed. In custody, they denied him nearly all privileges or rights under the Constitution. They denied him any opportunity to assist in his own defense. The official spin by the authorities was that they were protecting him from others. In questions of power, then let no more be heard of confidence in man, but bind him down from mischief by the chains of the Constitution. Thomas Jefferson. Chapter 50, Conclusion. The myriad of facts and perspectives, viewpoints, opinions, analysis, and information in the chapters, stories, and commentaries contained in this book range from cutting-edge, hard news, and comment to extreme and unusual perspectives. Uncomfortable material has not been swept under the rug. The truth has not been censored or logic skewed with contorted rhetoric. These things reflect the world as it now is, for better and worse. I present multiple facts, perspectives, viewpoints, opinions, analysis, and information included to help the reader see the overall plan to destroy political dissidents and the politically incorrect in America. As with all controversies, I stand ready to post any and all rebuttals and responses from people mentioned in the material. Journalism is, or used to be, the profession of gathering and presenting a broad panorama of news about the events of our times and presenting it to readers for their own consideration. It is believed that intelligence, judgment, and wisdom of the readers will help them discern for themselves among the data which appears in this book and to judge what is valid and worthy or otherwise. The idea of a free press in America is one that I and my colleagues hold in the highest regard. We believe in bringing our site visitors and program listeners the widest possible array of information that comes to our attention. We have great trust and respect for the American people and our worldwide audience, and believe them to be fully capable of making their own decisions and discerning their own realities. Among the vast information included in this work for your consideration, there will doubtless be some of you find useless and possibly offensive. But we believe you will be perceptive enough to realize that even the stories you disagree with have some value in terms of promoting your own further self-definition and insight. We are not going to censor the news and information contained in this book, for that is for you to do. We strongly recommend not assuming anything. Read, consider, and make your own informed decisions. People assumed the Warren Commission report was accurate. It was not. Chief Justice Earl Warren never should have allowed himself to be associated with the investigation of the Kennedy assassination because he was the one person who needed to be free of preconceived notions in the event that the commission determined that there was a person to prosecute. Unless, of course, the result was predetermined and known from the beginning that the one man, one bullet theory would prevail. With Lee Harvey Oswald dead, there was no one to prosecute, so that Earl Warren would never have to sit on the review of a case, and thus he was free to hold the investigation with the commission in his name, merely theater for the masses. People assumed the federal government would never conduct biochemical experiments on the general populace, but it did by the score. People assumed once that the world was flat. As you may recall, the definition of assume is ask you me. That's the end of the book. All right. I thought it was a very good book, and I'm going to read the pages that I have not read yet at some point in the future, and we'll get the whole book in one video. Thank you for your time, and if you want a PDF copy of this book, go to Year of Jubilee, Jubilee spelled with one E, and click on the Hinkson page. Thank you for your time.